Hi, my name is Andrew Kinney. I'm an attorney at Hoglund Law Offices. I practice Social Security disability law. Today I wanted to talk about dismissals of hearings by administrative law judges, otherwise known as ALJs. An important idea here is that when you apply and when you get your hearing, there can be a big difference from the time that you apply and the time you get to your hearing, sometimes as much as 2 years or more, depending on the area you live. By the time you get to a hearing, you would have gotten a letter roughly 3 weeks in advance stating the time and location of your hearing. Well, people don't always live in the same place, and sometimes they even lose contact with the attorney that's helping them with their Social Security claim. So sometimes we have dismissals of hearings when someone doesn't show up for their hearing. Now I want to distinguish dismissals from withdrawals from hearings, and withdrawals would mean that if someone is helping you with your Social Security claim and you decide that it's in your best interest to not pursue the hearing, for instance, there's not enough evidence and the attorney is giving you a good legal judgment on that, sometimes you withdraw your hearing request and you would refile and start over, and the last denial is the reconsideration denial, the level before. This is different. If you have a dismissal, that means that you didn't show and there was no explanation why you didn't show. If you have an attorney, you technically have a right to protect your right to a hearing by having the attorney show on your behalf, but at some point, for you to get a proper hearing, it'll be important to be able to make your next hearing, because there'll be at least a rescheduling of one hearing. So the idea is this: if you have a dismissal of your hearing and you're wondering what to do, the first thing you should do is call the hearing office on the number below. Certainly call your attorney if you have one and find out what do you need to do. Now, there are some factors that are hard to quantify. For instance, if it's over a year after you missed your hearing and you're first learning about it, I have not had any experience that someone's been able to get a new hearing. But if it's within a certain amount of time, a reasonable time since you've had your hearing and you missed it, what's very important is that you have an opportunity to offer what's called good cause. Here's why I missed my hearing. Here are the circumstances. It could be a family emergency, it could be homelessness, it could be many factors. But what the judges need to allow a new hearing and avoid a dismissal is a good reason you missed your first hearing. Now, if you have an attorney that's helping you, they can help you make sure that you get the good cause involved. Last winter, we would have examples of the snow being too bad to be able to get in, or in an inordinate amount of traffic. If there are some more practical reasons you couldn't make it on time to your hearing, those may have a better chance of getting the hearing rescheduled for good cause. So, if you have a hearing dismissal letter, or at least the threat of it, make sure to respond right away. If you find that your dismissal was too late and you lost your right to a hearing, what you can do is refile a new case, get an attorney, and help them reopen the prior case. So that can take an amount of time, but it is, at least in your situation, the best thing you can do to make up for what would be lost back pay. If you have more questions about dismissals by administrative law judges, or just general questions about Social Security disability, feel free to call our office at 1-800-850-7867. You can also visit hoglundlaw.com, and we also have other videos on different subjects to help you. Thank you.